Hello, everyone. Hope you guys are doing fine. My name is Marcio Cots, and we are going to start our data privacy online class in a couple of minutes. So in just a few minutes, we are going to start. I would appreciate if you could send me a message, just letting me know that you can hear me, that you can see me. Last class, we struggled a little bit with some technical issues. So I just want to be sure that everyone can hear me. So I would appreciate if you could send me a message. And we are going to start in within a few minutes. Okay, Sandeep, thank you very much for your feedback. It seems that it looks better than it was during our last class. Our last class, unfortunately, we struggled a little bit with some technical issues. So hopefully, everything is fine and you guys can see and can hear me perfectly. Today, we are going to talk about the same topic that we tried to address during our last class. We've got, a huge number of messages asking us to address the same topic again. As I mentioned it before during our last class, a lot of people from India, from Dubai, from Doha, from Pakistan, from Brazil, they are looking for data privacy content. Even people from the US and Canada. So we've decided to talk about some basic topics related with data privacy. So that's the reason why today we are going to talk again about the lawful grounds under the GDPR, the General Data Protection Regulation. So today it's going to be the same topic. It's going to be pretty much the same class, and I hope to be able to deliver the content in a way that you guys can hear me and you guys can see me. Okay, so I'm gonna share with you my screen, and we are gonna use here a short text on the 6 legal bases for processing personal data under the General Data Protection Regulation. So remember, if it's the first time that you are attending a data privacy class, you should know that the GDPR has its own standard on how to process personal data. If I had to explain what this standard looks like, it's pretty much like this. The GDPR has stipulated that for you to process personal data, you must fall into one of the 6 legal bases that you are going to find in the GDPR. So the GDPR has stipulated that you must comply with one of the 6 situations that has been described in the GDPR, and the 6 legal bases are pretty much the ones that we are going to talk about today. But beside complying with one of the 6 legal bases, you also have to be sure that you are going to process personal data in a way that you are going also to comply with the GDPR principles. So there are many principles in the General Data Protection Regulation, and that's something that will set some boundaries, some limits on how you should process personal data and be compliant with the GDPR. Besides making sure that you are going to have at least one legal base. Besides being sure that you are going to process the personal data compliant with the GDPR principles, you will also have to comply with the data subject's rights. So we want to be sure that our organization will be able to respond to any request made by the data subject. And besides that, the fourth topic that we also need to take care is data protection. We need to be sure that our organization will process personal data in a way that the personal data will be protected. So these four major topics are the major topics that will cover the legal aspect of the GDPR, of the General Data Protection Regulation. So we need to be sure that we will fit in one of the 6 categories of legal bases. We need to be sure that the way that we are going to process personal data will comply with the GDPR principles. We also need to be sure that we are going to be able to respect the data subject's right. And fourth, we need to be sure that our organization is prepared to process personal information, personal data, and protect the personal information. So today we're going to talk about specifically about the 6 legal bases for processing personal data. So one of the 7 major data processing principles of the GDPR is to ensure that personal data is processed lawfully, fairly, and transparently. To comply this principle, Chapter 6 of the GDPR requires any organization processing personal data to have a valid legal basis for that personal data processing activity. Think of these as scenarios in which it would be lawful to process data. GDPR provides 6 legal bases or 6 scenarios for processing personal data. So the first one that I want to talk about is the consent. The data subject has given permission for the organization to process their personal data for one or more processing activity. Consent must be freely given, clear, and easy to withdraw. So organizations need to be careful when using consent as their legal basis. For example, the age of automatically checked consent box is coming to an end through the GDPR. So the consent is the first. It doesn't mean that it's the most important. There is no most important or more important legal base. They are equivalent. So consent is just one of the 6 legal bases. A lot of people think that the consent would be the most important, or the consent would be the easiest way to be sure that you will have a legal base. But I would say that it's not like that. Actually, I have addressed and managed more than 100 projects all around the world, making companies comply with the data protection regulations. And the consent is usually, strategically wise, our last option. Why is that? Because the consent is hard to manage. Let's say that you are a retail chain and you have to process personal data of a large number of individuals. It's really hard to manage all the consent that you are going to get. It's hard to manage if people withdraw the consent. You need to keep track of that. And the other reason why it's difficult to manage your data privacy project on consent? It's because the consent might be the worst option. Because if you start asking for the consent and you start getting no as answer, your database will decrease and get smaller right away. So that's why strategically we try to follow under the five other legal bases, and the consent would be strategically the last option. Okay, very good. So the consent needs also to be freely given, clear, and easy to withdraw. So we need to be sure that our organization will be able to get the consent and manage the consent in order to prove that it was freely given, or that it is easy to withdraw the consent. Okay, so as a data privacy professional, as a DPO, a data protection officer, we need to carry out some procedures in order to be sure that the consent will be one of the legal bases, and we are going to be able to manage the consent. The second option and the second legal base that I want to talk about is performance of a contract. The data processing activities necessary to enter into or to perform a contract with the data subject. If the processing activity does not relate to the terms of the contract, then that data processing activity needs to be covered by a different legal base. But if it does relate to the terms of the contract, it means that you can process the personal data without any other, without having to follow under any other legal base. So the performance of a contract is a valid, legitimate legal base. Let me give you an example. Let's say that you are an e-commerce, okay? You are not going to ask for consent from the data subject in order to deliver the product that the data subject is going to buy from your website, from your e-commerce. Why don't you need to get a consent to process the personal data in order to deliver the product that the data subject bought from you? The reason why you don't need to get the consent is because you already have a lawful ground to process the data for that purpose. Because if the data subject is buying a product from you, you guys are entering into a contract. You guys are signing a contract. You guys now have an agreement between the data subject and the e-commerce, the controller. So that means that if I need to process the personal data to perform the contract, that means that I don't need the consent, because I already have a lawful ground to process the personal data for that specific purpose. So hopefully it's clear. If it's not clear for you, guys, be free to ask as many questions as you want. Okay? So for you guys from India, Brazil, Pakistan, Dubai, people who are getting used with this GDPR standard on how to regulate a personal data processing, and it's quite common for you guys to have questions if it's the first time that you are getting in touch with these kind of content. So just, feel free to ask as many questions as you want, and I'm going to be pleased to answer your questions, okay? So the third lawful ground that I want to talk about is legitimate interest. Under the GDPR, there is one lawful ground called legitimate interest. This is a processing activity that a data subject would normally expect from an organization that it gives its personal data to, like marketing activities and fraud prevention. So let me give you an example of legitimate interest. So as I've said, legitimate interest, it needs to be expected from the data subject. So if I have a relationship with an e-commerce, okay, there are some processing activities that would be expected from this relationship. For example, if I buy a product, online, using my credit card, I should expect that the e-commerce would carry out some fraud prevention activities just to be sure that no one else would be using inappropriately my credit card. So in this relationship between the customer and the e-commerce, it's expected that the e-commerce would process personal data for fraud prevention. So that would be considered legitimate interest. And of course, how would the e-commerce ask for the consent to carry out fraud prevention activities if there might be some hacker trying to use your credit card? That's not the data subject, and how come would that person would give you the consent for you to process the personal data? So that's something that it doesn't make sense to get the consent to run fraud prevention activities. So that would be considered legitimate interest. If legitimate interest is used as a legal basis for processing, the organization must perform a balance test. Is this processing activity necessary for the organization to function? Does the processing activity outweigh any risk to a data subject's rights and freedoms? Is the answer to either of those questions, if the answer to either of those questions is no, then the organization cannot use legitimate interest as its legal basis for processing. So every time that I'm going to use legitimate interest as my lawful ground, I need to make a balance test. And if the answer for any of those questions is no, that means that it wouldn't be considered a legitimate interest. Okay? So the fourth lawful ground that I want to talk about, vital interest. A rare, I wouldn't say so rare, but it's a specific processing activity that could be required to save someone's life. This is most commonly seen in emergency medical care situations. So that's why I don't say that it's rare, because if you are going to be a hospital, the hospital's DPO, if you are going to work with a dentist or something like that, that means that you are going to process personal data under vital interest. And that would be your lawful ground. Let's say that someone unfortunately has been shot. How come? Are you going to get the consent from the data subject, from the individual that has been shot, so you would be able to process personal data? It doesn't make sense. So that means that we have one specific lawful ground called the vital interest, and that lawful ground would be enough for you to process personal data for that specific purpose. So I wouldn't say that it's only for emergence. I would say that even for health interests, that would be considered at least legitimate interest. But a vital interest is also one of the possibilities depending on the situation. Okay? The fifth lawful ground that I want to talk about is a legal requirement. If you need to process personal data from an individual to comply with a law, that means that you don't need to get the consent, because let's say that the person doesn't give you the consent to process the individual's personal data. You wouldn't be able to comply with a legal requirement. It doesn't make sense. So that's why you don't need a consent if you are going to comply with a legal requirement, because that would be your lawful ground. The processing activities necessary for a legal obligation, such as an information security, employment, or consumer transaction law. Let's say that you are the DPO of a company, and you need to analyze all the procedures that that the company's human resource carry out, and be sure that the human resource would comply with the GDPR. Some of the processing activities carried out by the human resource would follow under the legal requirement, lawful ground. So that means that we don't need to get the employee's consent to process that specific personal data for that specific purpose. Okay? So anytime that you are going to comply with a legal requirement, it means that you already have a lawful ground to process the personal information, the personal data. The last one, public interest. A processing activity that would occur by a government entity or an organization acting on behalf of a government entity. So we don't see these lawful ground in a company's activities, because it's related to a government entity. But if you are going to work as a DPO or a data privacy consultant working for a government entity or an organization acting on behalf of a governmental entity, that means that you are going to use a lot these specific lawful ground. Okay? So these are the 6 legal bases. I also want to talk about some challenges for choosing a legal basis. Sometimes it's quite easy to identify the lawful ground. Sometimes it might be a little bit tricky. So, choosing the appropriate legal basis for processing is extremely important for several reasons, including these reasons. There must be only one legal basis for processing at a time. And that legal basis must be established before the processing begins. So every time that we are going to start, or even before we start processing the personal data, we need to identify what would be the right legal basis for processing that specific personal data for that specific purpose. Under the GDPR, organizations cannot establish a legal basis after processing personal data, or even have alternative between legal basis. Also, whichever legal basis is chosen, must be demonstratable at all times. An organization must be able to show internally to data subjects and to the regulatory entities what legal basis it uses for each data subject. For example, organizations must be able to demonstrate when and how a data subject provided consent or executed a contract. Just to give you two examples. So we need to demonstrate at all times, whichever legal basis is chosen, that we were using the right lawful ground. Also, the legal basis for processing has a significant impact on the way that an organization responds to data subjects' rights requests, because there are conditions, exceptions, and limitations on requests depending on the legal basis for processing. For example, let's say that a data subject required that you delete the data subject's personal data. And let's say that you have answered to the data subject that you are not going to delete the data because the lawful ground is this one, legal requirement. And if it's a legal requirement, it means that you need to keep the data, the personal data. But let's say that we have identified that that's not the right lawful ground, that the lawful ground is not correct, and maybe you don't have a lawful ground. That means that you answered to the data subject and you did not respect a data subject's right. You did not delete the data when the data subject has asked you to do so. So the legal basis for processing has a significant impact on the way that an organization responds to data subjects' rights requests. So be sure that you identify what would be the right lawful ground to process personal data. Also, if an organization uses multiple bases to process different data processing activities, the organization should be able to distinguish between which legal base is being used for which data set and respond correctly to the data subject's rights request. Because depending on the lawful ground, there would be different answers. Special categories of data, the sensitive data, such as race, ethnic origin, religion, trade union membership, biometrics, and health data, have unique legal basis for processing that includes preventive or occupational medicine and so on. So not all lawful grounds would apply in case you are going to process special categories of data, sensitive data. So be sure that you are going to identify, well, what's the right lawful ground that you are going to use to process sensitive data. It's important to note that one legal basis for processing isn't universally superior to another legal basis for processing, as I have mentioned before. The most effective legal basis for processing depends on the purpose for processing, the type of data being processed, and the relationship with the data subject. Choosing which legal basis is appropriate for processing activities is incredibly important. If the wrong legal basis is chosen, it could result in unlawful processing, no compliant response to data subjects' rights, and inadequate organizational and technical data processing controls. And that means that you would get a fine from the DPA, the Data Protection Authority. As I have mentioned before, there is one website that keeps track of every infraction, every fine that a European company has got for not being compliant with the GDPR, and some of them has got into some trouble because they choose the wrong lawful ground. So that's why the lawful ground is so important, and that's why I wanted to address this topic today. And that's why I wanted to repeat this class, because I knew that many of you were interested in learning a little bit more about the 6 lawful grounds. And unfortunately, we struggled a little bit with some technical issues during our last data protection online classes. So that's it for today. There is one question here, general question. Are the US universities subjected to European GDPR as they have EU students enrolled? Good questions, Sanjeev. Yes, they are, but not because they have EU students enrolled. Because the GDPR is not only for Europeans. It doesn't depend on the nationality. It depends more on where this person is located. So let's say that anyone that that lives in Europe and goes to the US to attend to a university in the US, or even sometimes even worse, we know that some universities, they have their online program, and sometimes the person is located in Europe. That means that even being an US university, they need to comply with the GDPR. Okay, that's mandatory. That's why some American companies have already gotten into some trouble, because they process personal data of individuals in Europe. It doesn't need to be European, but if the person is located is in Europe, or if you are offering products and service to people located in Europe, or if your company is located in Europe, then you have to comply with the GDPR. So 3 different scenarios. Your company is in Europe, you have to comply with the GDPR. Your company is not in Europe, but you are processing personal data of individuals who are in Europe. That means that you need to comply. You are going to offer products and service to people in Europe. You have to comply with the GDPR. So as a US university, you can either be offering service, online service, to people in Europe, or you can even have some people from Europe in your university. Once they go back to Europe, that means that they are going to be in Europe, and you are going to be processing personal data of people located in Europe. Okay, hopefully that answers your question. I'm really glad to have you guys. I know that many of you are going to watch our online class on demand, not live. We know that our biggest audience is on demand. So that's the reason why we have recorded this class on the 6 lawful grounds. Okay, so for those who are getting in touch with data privacy matters for the first time, it's good to study the lawful grounds. Okay, we are going to also talk about the GDPR principles, and we are also going to talk about the data subjects' rights. Okay, so it was great to be here with you guys. Hope to see you soon. Take care. Bye-bye.